motions pending for more than 6 months. You ranked number 3. You all came on at the same time. You all had the same problems with COVID. You're the 3rd worst. You really think of all the other district judges in the 7th Circuit, you're the one that ought to be promoted? Judge, welcome.
Thank you.
You are probably the least productive member of your district court, isn't that right?
Well, I have not considered myself in those terms, Senator.
Well, let me explain what I mean. You have 125 motions pending that you've declined to decide.
Let
me finish. That's more than any other district judge in the entire 7th Circuit. In fact, you rank 7th highest nationally, do you not?
I am not familiar with those statistics, Senator Kennedy.
You haven't looked?
I did look in preparation for this hearing, but I didn't compare myself to others.
You haven't seen that you ranked the 7th the worst in the country in terms of making decisions?
You are the first to tell me this. And I think for me, I stress the quality of my decision making. And as I explained, I came on, I was the first district judge to come on during this administration.
Yeah, but so were all the others. I mean, there have been 68 district judges confirmed in the 117th Congress. In terms of motions pending for more than 6 months, you rank number 3. You all came on at the same time. You all had the same problems with COVID. You're the 3rd worst. You really think of all the other district judges in the 7th Circuit, you're the one that ought to be promoted based on this record?
Senator, this is something that I've discussed with my fellow judges. Many of us new judges from.
I thought you said you'd never looked at these statistics.
I haven't. These particular statistics I am not familiar with. But in terms of new judges, both from the current administration and the former administration, we are quite a collegial bunch, and oftentimes talk about the pressures of a new judge and the way reassignments work in our district, which is that you get, for example, 300 cases.
Yes, ma'am, I understand. I'm familiar with the procedure in federal court. Here's what I'm trying to understand. Why is your record so bad?
Well, I don't view it that way, Senator. When I look at the quality of my decision-making, the feedback that I get from parties,
of course parties are not going to criticize you. They want you to rule in their favor.
I understand, Senator Kennedy.
I mean, that's just the way it works. Help me understand why you have such an abysmal record in moving cases. I mean, it costs a lot of money to litigate, and people are paying lawyers, and time is money. And of all the district court judges in the 7th Circuit, you're the worst in terms of moving cases. Why do you think you deserve to be promoted over all of those others?
So, Senator, again, I'm not familiar with the statistics, but I stand by my record and that I give parties what they need. I think, I am regularly in my courtroom. I am regularly issuing decisions. I just came on at a very difficult time where there was a backlog in the courts.
So did everybody else. Let me ask you, when you were a partner in your law firm, you volunteered to write a brief on behalf of the Brady Center. You wrote the brief, and this is what you said. You volunteered for this. You weren't being paid. Is that right?
This was a pro bono case that one of my partners brought in, yes.
You said, quote, assault weapons may be banned because they're extraordinarily dangerous and are not appropriate for legitimate self-defense purposes, close quote. Tell me what you meant by assault weapons.
Thank you, Senator Kennedy. Just to clarify there, I was local counsel. Our Supreme.
Yeah, but you wrote the brief. Tell me what you meant by assault weapons.
Senator Kennedy, actually, I did not write the brief. The brief was written by.
You signed the brief, though, didn't you?
Correct. I signed the brief.
When you sign a brief, you're testifying to the court that everything in it is true, right?
Yes.
Okay.
So
they're your words in terms of the court, right?
Well, you're correct, Senator Kennedy. I would never sign.
Tell me what you meant by assault weapons.
So I am not a gun expert, and at the time, that brief I think was about 10 years.
You were giving the court advice about, say, ban assault weapons. What is? You told the court you were an expert. Just tell me what you wanted to ban.
Senator, sitting here today, as I said, I did not write that brief. I was local counsel.
Sign the brief.
I understand. At the time,
Tell me what you wanted to ban. That's all I'm going to know, Judge.
I don't remember the exact definition of assault weapons in the ordinance that was at issue.
So you submitted a brief to an appellate brief. You signed it, and you don't know what. And you said abolish assault weapons, and you don't know what you wanted them to abolish.
Senator, at the time that I signed the brief, I read the brief because our Supreme Court required an Illinois bar member to sign the brief. I was not responsible for researching the content.
You were responsible for the brief.
Absolutely. And sitting here today, I do not remember the characteristics of that were cited in the ordinance for the assault weapons ban. It's not an area of practice that I have specialized in. I'm sure 10 years ago, I could have answered your question.
And
it's sitting here today.
You think you deserve to be promoted with this record?
Senator, I stand by my record. I stand by my record.
Senator Butler.
Thank you, Mr. Chairman. Congratulations to you and your...
It was a confrontation that stripped away the ceremony of confirmation hearings and exposed something raw beneath the marble calm of the Senate chamber. Senator John Kennedy leaned forward, eyes fixed, voice slow and deliberate, as he asked the question that no one else in the room dared to phrase so plainly. Why is your record so bad? The silence that followed was not just awkward, it was revealing. Before him sat a nominee for one of the highest and most enduring roles in American justice, a lifetime appointment to the federal bench. But Kennedy wasn't interested in platitudes or polished resumes. He was interested in accountability, in whether the person entrusted to judge others could be judged herself by the most basic metric of public service: performance. He did not shout. He did not sneer. He simply presented the numbers, stark, undeniable, unspun. 125 undecided motions, the 7th highest backlog in the entire nation, 3rd worst in her circuit. Facts that, when laid bare, said more than any opening statement or political endorsement ever could. And when she tried to explain that she hadn't compared herself to others, that she stressed the quality of her decisions, that she came on during a difficult time, Kennedy cut through the fog of excuses with the quiet persistence of a man who knew what the public was thinking. Every day, Americans go to work. They show up, they perform, and they're judged by results. Shouldn't a federal judge be held to the same standard? In that moment, the hearing became something larger than a personnel inquiry. It became a mirror, reflecting the growing distance between the governed and those who govern, between the citizen who must account for every hour and the official who hides behind process and privilege. Kennedy pressed again. Help me understand why you have such an abysmal record. Each word landed with surgical precision. He wasn't bullying. He was prosecuting on behalf of the American people who expect their courts to deliver justice swiftly and fairly. He spoke of cost, of time, of litigants waiting months, sometimes years, for decisions that should have come within weeks. In his calm drawl, you could hear the frustration of millions who've been told to trust the system, even as the system drags its feet. The nominee, caught between deflection and deference, tried again to soften the blow. She valued the quality of her decision-making, but Kennedy wasn't buying it. He knew what every working man and woman knows, that quality without efficiency is failure dressed in vocabulary. Justice delayed is justice denied. Then came the second half of the hearing, a turn that revealed more than perhaps the nominee intended. Years earlier, she had voluntarily and proudly signed a legal brief defending an assault weapons ban. A brief that declared such weapons were extraordinarily dangerous and not appropriate for legitimate self-defense purposes. Kennedy, having done his homework, pressed the simplest of questions. Tell me what you meant by assault weapons. Again the air tightened. She hesitated, stumbled, backtracked. She hadn't written the brief, she said. She was only local counsel. She didn't remember the definition. She wasn't a gun expert. It had been 10 years. Yet she had signed her name, sworn to its truth, and now, under oath, she could not defend a single word. Kennedy's patience thinned. You signed the brief. You told the court everything and it was true. And you don't know what you wanted them to abolish? It was the kind of question that cuts across ideology, that reaches into the heart of credibility itself. If a judge cannot stand by her own record, how can she be trusted to judge the records of others? The exchange was brutal, yes, but it was not cruel. It was the kind of accountability that once defined public life, the kind that too many in Washington now call uncivil. Kennedy was not there to humiliate. He was there to illuminate, to expose the hollow space between rhetoric and reality. He spoke for those who have grown tired of watching nominees recite the language of neutrality while hiding their convictions behind procedural fog. He spoke for those who believe that the bench should not be a place for political reward, but for moral courage. In Kennedy's voice, there was something more than skepticism. There was the echo of an older America, one that believed government service was a sacred trust, not a career move. His questions reminded the nation that power without accountability is the slow poison of democracy, and that no robe, no title, no endorsement from the powerful can shield a public servant from the truth of their own record. The nominee's final defense, "I stand by my record," landed hollow, echoing against the marble walls, because the numbers stood too, the motions unruled, the cases unmoved, the promises unkept. And when Kennedy leaned back in his chair, the work was done. The hearing had peeled away the talking points, the polish, the politics, and what remained was a simple lesson. Accountability is not cruelty. It is the cornerstone of justice. In that chamber, beneath the flags and the seal of the United States Senate, one voice reminded the country that the law is not just about statutes and citations. It's about trust. Trust that those who wield power will do so with diligence, honesty, and clarity. Trust that the scales of justice are balanced not only by intellect, but by integrity. And if that trust falters, even for a moment, it must be restored, not by rhetoric, but by truth. Because in a republic, titles mean nothing if they rest on unanswered questions. This is Liberty Congress of USA. We stand for transparency. We stand for accountability. And we will keep asking the questions that power refuses to answer. Subscribe now and stand with us as we shine the light where it matters most, on the truth.